maybe least we can start at the beginning with the denialism, the AIDS denialism of the early 2000s, where there was clear evidence of HIV and the fact that treatment saved lives, and the then president's approach, which was to deny that this existed or that treatment should be allowed, and the kind of notion that the treatment was toxic and was Black people were being targeted, was completely not evidence-based. And the kind of work that was done early on was to put the evidence on the table, and to bring that evidence to courts, and to bring that evidence to people living with HIV so that they understood what HIV was and what treatment was, and that they could then speak to others in their family and friend network, and ultimately that work led to access to antiretrovirals. You could look at that arc as an important failure, but then ultimately having access because of the rights-based approach. So the treatment action campaign case was a case on the Section 27 right to access healthcare services, and related particularly to prevention of mother-to-child transmission. And it was doctors who came to court as a collective and put the evidence before court. So I think that arc is really, really important. And then there are other arcs around access to healthcare services. One is the broader arc on access to medicines, where we are now, where we're not doing a case at a time, but we're actually trying to change the whole system. And what Section 27 says is that there must be progressive realization of the right to access healthcare services. And it's the duty of the state to put in place those structures. The key partnership continues to be with the Treatment Action Campaign, particularly on health work. And the Treatment Action Campaign was the partner of the AIDS Law Project on the early cases on antiretroviral treatment. And we've continued to work with TAC on access to medicines, but on all of the health systems issues, because they also expanded from only working on HIV to working on the much bigger system. So we have represented them in cases on access to medicines on cancer, for example, because we know that there's a link between HIV and cancer. Their core mandate continues to be HIV, but they're certainly doing a lot more work, and we've been partners with them since the beginning, I guess. The work that we do with the Fix the Patent Laws campaign is about raising the same issues we did with HIV, which was that the kinds of monopolies that pharmaceutical companies enjoyed at the time with HIV drugs are very similar to cancer and other drugs, and even the newer HIV drugs. And so the work that we're doing there is to make sure that we are not having to go disease area by disease area and drug by drug, but actually to look at the whole system and see what are the barriers within the legal framework that are causing high prices. And so that campaign has been successful in that we have been able to educate the public about this link between intellectual property and access to medicines, but also that we've been able to achieve a national policy that makes the link between public health and the developmental state of South Africa with the private rights of corporations. And that policy, after many years of campaigning, was finalized in 2018, and is a major victory for access to medicines. But obviously is only one stage. The next stage then is for law reform to happen to actually change the Patents Act in order to address things like evergreening of patents, and also just the examination of patent applications. And the last frontier is this bill that is supposed to be tabled in the next couple of months, which will then change the Patents Act and related legislation to ensure that we are actually changing the structure of the intellectual property system. The health market inquiry is something that happened because of Section 27. So we recognize that the inequality in the health system made it unsustainable, and that we needed to have real information and evidence about how the private health system was working, because it's quite opaque. There's no pricing structure, and so on. So we decided to start advocating to the Competition Commission to do an inquiry on the basis of the competition law amendment, which was brought into effect shortly before this commission started. And so we proposed that there's a market inquiry mechanism that's available now, and that the Competition Commission should focus on the private health sector as its first, which it then did. So I think the important thing here is that we were able to frame this debate around private health with NHI, and we made that link quite clear through our submissions. And that it was not talked about in the way it is today, that the private sector has a particular role to play, and they can't just be left out to do what they want whilst we do NHI in the public system, which would be quite convenient, right? Have your experiment in the public system, we'll carry on. And so part of our messaging was to connect those things, because the equity issue is between those two systems. And the point is to make both of those systems more equal. So it's not to make the public system more equal or to make the private system more equal. It's to make the health system more equal. Health is often the thing that enables people to realize their potential. And so for me, being part of this democratic project where we are seeking social justice, and seeking to create a society that we believe in and that we agree fundamentally should improve people's lives, and that we need to consider our own humanity in the work that we do as human rights lawyers, social justice activists, and to see people. I would like to think of it as a human rights tradition in South Africa, because we have a long history of lawyers intervening even during apartheid South Africa and working through the legal system to try and make change, social change, and to try and assist those who were engaged in the struggle. And so we stand on the shoulders of all of those people. And so the kind of current human rights work, engaging in health and human rights, is building on that legacy. And I think that's really special. It's special to me, and I'm always excited to be able to talk to some of the people who were there at the time, some of whom became Constitutional Court judges, for example, and who continue to have a great passion for constitutionalism and the power of the Constitution to transform a society.